Tonight on Nation and Nation, unpacking the Quebec Court of Appeal's decision on the Liberal government's Indigenous child welfare law.
I think it's pretty big on a few different fronts.
Why both Canada and Quebec are taking the fight to the country's highest court.
Canada was largely happy with the decision, other than the exclusion of those two clauses, and we'll be there with Indigenous people and take this all the way to the Supreme Court.
And when the judges do hear the case, it'll be Quebec that faces the tougher challenge, says lawyer Naomi.
About time that this gets before the highest court, that we get some clarity on that. I think we're going with a very strong judgment on a very crucial issue.
Plus, with the convoy crackdown under scrutiny, AFN National Chief Roseanne Archibald addresses MPs with her concerns.
I want to be clear that First Nations are not terrorists, nor should they be branded as such when they are involved in civil actions.
Hello, I'm Brett Forster, and welcome to Nation and Nation. Battle lines have been drawn as the fight over the Liberals' Indigenous child welfare law prepares for another round before the courts. The legislation was supposed to hand over jurisdiction of child welfare to Indigenous nations, but last month, Quebec's top court cancelled two sections of the law, but upheld the rest. On one side, the federal government is now appealing that cancellation to the Supreme Court, while Quebec aims to have the rest of the legislation squashed. Indigenous Services Minister Patty Hajdu is in Atlantic Canada visiting First Nations. Hello, Minister, and welcome to the show.
Nice to see you, Brett.
First, why, in your opinion, is more litigation required on this particular file?
Well, from our perspective, more litigation was not required on the file. In fact, we created a law that, with Indigenous people, as you know, it was co-developed to restore care and control of First Nations family and child services to First Nations communities that wish to retain that control or to regain that control. And we were very confident in the law. Quebec appealed the law and its application in the jurisdiction of Quebec. In fact, the ruling, as it's been explained to me and my team, is fairly groundbreaking, with some exceptions. And so from our perspective, it is worth asking the Supreme Court to review the law and to uphold the rights of Indigenous people to have self-determination and the ability to regain control over how child and family services are delivered in community.
What would the impact on this law be if the prior decision stands as is and those two particular sections are struck down?
Well, it does leave a question mark for First Nations communities, in particular around how the law is applied for First Nations children that belong to their communities. And, you know, I have had conversations with the minister responsible in Quebec, have really pressed upon him to encourage him to work with his colleagues to honor the spirit of C-92 and the intent of C-92, and yet we see a reluctance from the province of Quebec to do so. This is important, though. This is a huge piece, as your listeners will know, to the next generation of Indigenous children, to the restoration of family, to the protection of language and culture. And so the federal government has made a commitment to Indigenous people that we will uphold the law and fight for the law to be recognized at the highest court of our land, which is the Supreme Court.
You mentioned your conversation with Quebec there. What's your government's response to the province filing its own mutual appeal of the decision?
Well, our response is, of course, our own filing to the Supreme Court. And again, our commitment and my personal commitment to Indigenous people that we will defend C-92 and that we will defend their inherent rights to self-determination. And I think by the federal government pursuing this appeal to the Supreme Court, that is the kind of litigation that will be helpful to First Nations people.
How concerned are you about other provinces potentially intervening and maybe backing Quebec on this?
Well, I would hope that that's not the case. We've had some very positive conversations with other provinces, for example, Manitoba, Alberta. I was in Wabaseemoong just last week signing a historic agreement to transfer care and control of family and child services to Wabaseemoong, and Minister Rickford was there. This was very good news for the community and a very positive, I think, spirit of intent from Ontario. So I'm hoping that provinces and territories will realize that it's not just in the best interest of Indigenous children and families, but indeed all of the citizens of their provinces. This is reconciliation is not just the right thing to do. This is about the smart thing to do as a country. You know, we have in many provinces and territories, the fastest growing population is indeed in Indigenous communities. And when children have that opportunity to grow up surrounded by loving family and community in ways that honor culture and support healthy development, that's good for everyone in that province. So I hope that provinces and territories will continue to see it that way.
Let's talk a little bit more about those agreements. While all this plays out, what happens to those coordination agreements that have already been signed under this law?
Well, certainly in Quebec, we are looking at how this will affect Apitchawan, and you know they are the first community in Quebec to have their own customary code, their own laws, if you will, about how to provide care to children and families in their traditional territory and their communities. And we've given our word to Apitchawan that we will defend their rights, and we will also support them in that transition. The challenge will be working with the province of Quebec to understand how that will impact children in care in Quebec that are members of the Apitchawan community, and how we will ensure that those children also have every right and opportunity to celebrate the culture and language that is their birthright. As I've said, though, to Indigenous leaders across this country, Canada will defend that inherent right. That is the intent behind the legislation, and we are working now as a cabinet team to understand how best to work with provinces and territories that are reluctant to do so. One of the ways that we are, though, as I mentioned earlier, is to ask the Supreme Court to review C-92 and to uphold C-92.
Should communities who want to assert their jurisdiction over child welfare and avail themselves of this law wait until a final decision is rendered, given some of the uncertainty?
I think there's lots that communities can do across the country to prepare for assuming the control of child and family services, regardless of which province or territory they are in. And I think that this decision that the Supreme Court will eventually make will hopefully strengthen their case. But certainly, as I said, the decision by the Quebec Court of Appeal was a landmark decision and does provide a lot of room for First Nations and Indigenous communities in Quebec to be able to do that work now. And I would say that it's important for any community, any Indigenous community that is interested in doing that work to continue, because this is something that will affect this generation, the next generation of children, and the federal government will be a strong partner in that work.
I suppose as a follow-up, at the end of the day, is this law still salvageable if the provinces can ultimately override Indigenous laws?
Well, let's be clear. The province cannot override Indigenous laws, and that's not what the ruling said by the Quebec Court of Appeal. There are questions, though, about some aspects of the law. In fact, this has been noted as a historic and land-breaking decision by the Quebec Court of Appeal. So I would say that in large, this is good news for Indigenous communities. It's good news for the legitimacy of C-92, the legislation that enables self-determination in this space. We have questions about the exclusion clauses, and we'll fight to make sure that the integrity of the entire law is upheld. But I would just reiterate that, in fact, Canada was largely happy with the decision, other than the exclusion of those two clauses, and we'll be there with Indigenous people and take this all the way to the Supreme Court.
All right, I'd like to switch to a related topic now, which is the proposed resolution of child welfare litigation. The court directed the parties to finalize a comprehensive settlement by the end of this month. How close are you to reaching that goal?
Well, the parties have been working incredibly diligently on the two components of the agreements in principle, and you're well aware of them, I know, Brett, but I will just reiterate for your listeners. One stream of the agreements, or one section of the agreement, is around compensation, and the second section is around long-term reform. Both of those pieces of work have been proceeding very well. The parties have been meeting on a regular basis. I think we're getting closer to a final agreement, and I know that there are still many details to iron out, but there's a real spirit of, I think, collaboration and determination to get to that final agreement.
Okay, Minister Hajdu, we do have to leave it there, but thank you for your time.
Thank you very much, Brett.
After a short break, I'll take a deeper dive into these implications with lawyer Naomi Metallic. Welcome back. We are keeping the focus on the legal battle over Indigenous child welfare legislation. Last month's decision from the Quebec Court of Appeal is not exactly straightforward. So for a broader look at what it means, joining me now is Naomi Metallic. She is a lawyer involved in the case and an assistant professor at Dalhousie University's Law School. Welcome to Nation and Nation.
Thank you very much for having me.
So before we get into the details, generally speaking, how big could this case end up being?
I think it's pretty big on a few different fronts in terms of being part of a solution to the crisis of Indigenous child welfare, as part of the Government of Canada using its legislative powers to do good. And probably one of the most significant things for Indigenous people in this country is what it says about the inherent right to self-government and what it could mean for it.
Well, can you draw that out a little bit? The feds say this is the first time a court has recognized Indigenous people's constitutional right to self-government. What is actually in this decision on that front?
So, I mean, it stems from the fact that in the legislation itself, the federal government said that the inherent right to self-government exists, and it includes the right to self-govern over child and family services. What the court did with that is agree and in fact say that the inherent right to self-government has been part of government policies and some self-government agreements. And we've seen, some court decisions that sort of touch on it in various ways, but they've sort of brought all of those things together and say, look, it exists. And in fact, it exists as a generic right. Meaning it doesn't require Indigenous people to have to go to court on a case-by-case basis to prove it, and that includes the right to child and family services, to a jurisdiction over child and family services.
The decision also said, however, that Indigenous laws cannot prevail over provincial laws when they conflict, which was an important part of that law. Can you unpack that finding a little bit?
That is sort of a misconception, because what the court says is that the way that the government tried to achieve paramountcy, what you're saying, the Indigenous law prevails over the a provincial law. That's what we call paramountcy in legal speak. What they said is that's achievable, and in fact, that is the default. So they said that, but what they said is that it couldn't be achieved the way Canada wanted to, which is by using its own paramountcy over provincial laws and sort of giving that to the Indigenous people. What the court said instead is that happens through Section 35, and that will be the default. Reconciliation requires that. But in certain cases, it could be possible for the provinces to prove that its laws should be paramount if it meets the test that has been developed under the case law called a Sparrow test. It allows for justification of provincial or federal laws over Indigenous laws or activities in certain cases. But the court also said it's an extremely high threshold and very difficult to meet. And so it doesn't mean, as some people have interpreted, that provincial law will automatically prevail. But A lot of people who have been working hard on developing laws for Indigenous communities around child welfare say they needed that easier way, that easier approach that had been in the legislation, because it's very hard to explain what I just explained to you to everybody. People don't understand it. Provinces might have the wrong misconceptions. So it's in fact much easier and much and really facilitates the exercise of inherent jurisdiction if we have those provisions in the law, which is what Canada has cross-appealed on.
All right, and moving on a little bit, there were dueling appeals filed on the same day by Canada and Quebec. First, what do you make of the effort by Canada to get these two sections reinstated?
I think it's laudable. Like I say, I think that there are real practical reasons. Perhaps actually in principle, I'm not entirely sure whether they would result in the same difference, but I think from a practical perspective, in terms of really facilitating the exercise of self-government, which is how I think the federal jurisdiction ought to be used to support and protect and to facilitate the exercise of self-government, that they should make a go of it by asking the Supreme Court to reconsider how the Court of Appeal approached that.
On the other hand, what if Quebec gets its way with this appeal and the whole legislation is wiped, or the feds have to go back to the drawing board in some form?
Yeah, but I mean, we're on this crash course to have that issue finally resolved. The issue of the inherent right to self-government and governments in Canada not legislating, letting everything go to court, letting all of this be uncertain, that's not been helping anyone either. So, you know what? I think it's about time that this gets before the highest court, that we get some clarity on that. I think we're going with a very strong judgment on a very crucial issue to Indigenous people, the right to control and make decisions with respect to our children. So there couldn't be a more important case to bring this issue before the court. And, the court had an earlier decision in 1996, right after the fail of the Charlottetown Accord. It's a really different time, and we've seen things develop in a really different way. So I think it's definitely time for this issue to come before the courts.
Well, if it is, as you just mentioned there, a fairly strong decision, who has the harder case to make to overturn parts of it? Is it Quebec or Canada?
Quebec. Quebec has the harder case. I mean, the law is very supportive. It's the judges on that panel at the Quebec Court of Appeal all reputed very strong judges, and the analysis is very strong. Although I think there are some weaknesses on them overruling those two provisions, but no, the Quebec has the harder case for certain, especially when its own provincial court or appellate court didn't side with it.
Well, there's always a sense of urgency when we're talking about children. When might the court hear these arguments, and what would that process look like moving forward?
Sure. So it's not a process for leave. Usually you have to apply for leave, but references go directly to the court. So that's going to speed up the timeline. It looks like the parties' factums will have to be filed by early summer. And I assume that there's going to be a lot of different intervening parties beyond the 5 that were involved in the Quebec Court of Appeal. By my calculation, or my colleague's calculation that I'm borrowing, he had calculated that we'd probably be before the court by October or November of this year, 2022. Things are moving at a fast pace, and but I think it is an important issue to come before the court sooner than later.
Can you give me a brief overview of what you will be arguing when this hearing ultimately does start?
We don't have instructions yet. I think we'll be keeping close to, we're on for the Caring Society, and we will be raising the historical context about why this is so important, the link to child welfare and residential schools, the various principles that the court should have at the back of its mind when it is considering this issue, including substantive equality and how this legislation furthers substantive equality in Jordan's principle. So those will be some of the things that those were things we emphasized at the Court of Appeal, and I'm assuming we'll be emphasizing that again before the court for the Caring Society. But yeah, I assume there's going to be a bunch of other parties coming, some who will be emphasizing more on the self-government element of the argument, but they're all important parts of this legislation.
One thing that strikes me about this case is that we have essentially two colonial governments squabbling within a colonial legal system about inherent Indigenous rights. I'm interested to hear your thoughts about how we can approach that contradiction.
How do we leave Canada? I mean, in some respects, you know, these things have to change, right? It's not as if I at least am of the view that in order for us to be able to exercise our inherent jurisdiction, I mean, it's an inherent right. We don't need another government's recognition on the one hand. But on the other hand, to exercise it in a meaningful way with funding, and also to make sure that the other governments do not inhibit or infringe or, stop us from doing that. We need the cooperation of other governments. And so what Canada was trying to do with this legislation, though not perfect, is a real good step in the right direction. And I want to see Canada do that in other areas, not just child welfare, like in health and policing, like they're doing now, and in other and beyond. And in fact, provinces have a role to play in facilitating reconciliation. So I don't think we're going to get away from the fact that we are, living here with other colonial actors. We're trying to make them be better and do better. But I don't think that there's a way around that. But I do think that all of this is heading in a much more positive direction than we've been in for the last 20, 30 years. We've sort of been stagnant on the issue of self-government, at least in a real general national sense. And it's time to turn the page on that.
All right, we have to leave it there. Naomi Metallic is a lawyer and law professor. Thanks a lot for your time.
Thank you.
Coming up, highlights from the AFN National Chief's testimony on the Emergencies Act during the House Finance Committee earlier this week. Welcome back. After the Freedom Convoy occupied downtown Ottawa for 3 weeks, the Trudeau government invoked the Emergencies Act to clear the streets and arrest dozens of protesters. Many criticized the government then and since. Now, the House of Commons Finance Committee is studying the issue. National Chief Roseanne Archibald addressed MPs this week. She expressed concerns the act could be used against First Nations water and land offenders because, she said, there is systemic racism in government and enforcement institutions.
The convoy was provided with much leniency from the start because the non-Indigenous participants were not initially considered or deemed a threat until it was too late, and thus the Emergencies Act was invoked. I do want to just state that there is a stark contrast on how First Nations people are treated when they are involved in civil actions, and there is a need for dignity and respect to be afforded to First Nations when they are being vocal in their disagreement with government on legislation and policies. First Nations people are often viewed with a different lens and met with aggression by law enforcement almost immediately, not 3 weeks later.
Archibald also spoke about the federal government's crackdown on the convoy's use of crowdfunding.
For example, First Nations have used these crowdfunding websites for raising legal defense funds. This will be a big step backward for Canada, as it will take us back to 1927, when the Indian Act made it illegal for First Nations people and communities to hire lawyers or bring about land claims against the government. Further, in 1951, Canada amended the Indian Act to make it illegal to obtain funds or legal counsel to advance Aboriginal title cases. We need to move on a healing path forward and not go back to oppressive, suppressive legislation.
And Archibald said she is concerned about broadening the scope of Canada's anti-terrorist financing laws.
And I want to be clear that First Nations are not terrorists, nor should they be branded as such when they are involved in civil actions that protect and uphold their constitutionally protected treaty and inherent rights in this country.
That study is set to continue in the coming weeks, but that's all the time we have tonight on Nation to Nation. I'm Brett Forster, wishing you well on this St. Patrick's Day Thursday. Have a great evening, and thanks for watching.